Good morning and welcome to Guardianship and Advocacy, Protecting Senior Rights. I'm Sonia Gibbons-Reed, the State and Community Engagement Analyst for AARP Illinois, and I'm thrilled to have you all join us today. Our discussion is on elder law with a special focus on guardianship challenges and solutions. To shed light on these important topics, we have our esteemed guest, Steve Andersson, joining us today. Steve Andersson is an elder law attorney and contractual lobbyist for AARP Illinois. Welcome, Steve.
Thank you so much. It's a pleasure to be here with you.
Great. Before we get started with our conversation, I'd like to remind our Facebook and YouTube viewers that you can ask questions and share your comments in the social media feeds with today's guests. We'll do our best to address as many of your questions and comments as possible during our conversation. Today's questions cover a broad range of topics and can serve as a starting point for discussions, planning, and consultation with your family and professional advisors in elder law, financial planning, and healthcare. So with that, let's begin. What is guardianship in the context of elder law, and when is it typically needed?
It's a great question, a great way to kick us off. One thing I want to say at the very beginning is that the information that I'm going to convey today is not a specific state's law. It's generalized because we don't know who's going to be listening. I'm a lawyer in Illinois, so most of it will have an Illinois-centric approach, but what I'm trying to do is genericize it so that if someone's listening from any other state, it will have general application to most states. But you always have to check with your own attorney in your own state to make sure that you've got the up-to-date and correct information. Having said that, so what's a guardianship? Why is it needed? So the question of what a guardianship is it's a court-appointed process by which someone else is named to take care of the affairs, both physical, mental, and financial for another person. So in the context of elder law, generally what that means is someone has reduced capacity for any of a number of different reasons, anything from dementia to physical limitations, and then there's a need for it. Now, that it's actually rare these days that you need a guardianship. So I don't want people to feel like this is an inevitability. It's not. A lot of the things, and I think we're going to talk about them, there are ways to avoid the need for a guardianship through proper planning. But if for any reason those don't come to pass, it's okay. That's what the guardianship process is for. And it's about ensuring the protection of the person. It's not about the family. It's not about the guardian. It's all about the best interests of the person.
Okay. And how is a legal guardian appointed? And what is that process?
Sure. So the process starts with a court filing. And again, this is kind of Illinois-centric, but I think it's probably true of most of them. In Illinois, we require what's called a physician's statement, determining that there's a need for a guardianship. And that's put there as a bit of a protection for the person who the guardianship is being sought after, because we don't want anyone filing it at any time for any reason. There's got to be at least a threshold good reason, and we think a physician's statement is the way we do that. Once that's filed, then a court hearing is convened pretty quickly. Guardianships are important. That means that somebody's in some level of danger for a variety of things, anything from financial to just their personal safety. So it usually happens within about 30 days, and then there's a hearing with a judge. There's some background work that happens where if a judge wants it, he can appoint an attorney for the person who the guardianship is being sought after, the senior typically. And they can also, each side can prepare if there is even each side. It's often that these are agreed to processes.
Okay. And what are the responsibilities and duties of a legal guardian, or does that vary based on the situation?
Your instincts are exactly right. It does vary on the situation. It can be anything from what we call plenary guardianship or full guardianship, where the guardian is responsible for absolutely everything from daily life to finances to just everything. But the whole idea of a guardianship in the court process is to tailor it to your specific need, you, the senior. So the judge can say, you're in pretty good, situation with regard to your health care. So I'm not going to appoint any duties for that for the guardian. The guardian's there only for the money aspect, or vice versa. It'll just depend. So it's tailor made for your situation. And the other nice thing about it is that it's adjustable. So that if at the beginning, everyone thinks, well, we need to do X, Y, and Z, but it turns out we don't really need to deal with X. The senior can still decide certain things for themselves. It can be adjusted as well.
Okay. So can family members automatically become guardians for their elderly loved ones, or is court approval required? And I think you kind of answered that, but is that every case?
Court approval for a guardianship is required. There are other documents where you can name who you want to be the guardian, and the judge will take that into account, but a judge is not required to appoint the family members. Their job is one thing only, to appoint somebody in the best interests of that senior.
Okay, so that kind of answers the next question.
I'm sorry.
That's okay. What criteria does the court consider when deciding whether to grant guardianship over an elderly person?
Yeah, they take into account, or they can take into account, absolutely everything. So that means your physical and mental health, your financial situation, your life experiences. They'll even, they'll certainly take into account any sort of information that can be provided about why the decision was made to seek a guardianship. All of those facts and circumstances, take those all into account. And then, like I said, the standard that the judge has to apply is the best interests of the senior, nobody else. That is their single goal.
Okay. And how can someone protect themselves from the appointment of an unwanted guardian?
So that's a great question, because there are cases where people, the senior, I'm just calling the person who the guardianship is being sought after, the senior may not want the guardianship, right? They might feel they're in perfect capacity. So there's a couple of things. One, if you execute a power of attorney, you can designate on that power of attorney, at least here in Illinois, I always have to say that, you can designate who you want to be that guardian, and you're doing that in advance. So when you still have your full capacity. So that's used as a protection, because that will be raised in case some unwanted person is trying to gain control. The other is that physician statement, like I said, that certifies that there's a real need for this. The judge is another part of it. And then the other thing you can do is you can also have what's called a guardian ad litem. That's not the guardian. That's a person who reports to the judge and does an independent evaluation of you, the senior, to determine if a guardianship is really warranted. And also to make sure that the person who's trying to get appointed as the guardian is the right person for the job. So there are a number of safeguards or steps along the way.
Right. Okay, perfect. Are there alternatives to guardianship that can be used to protect the rights and well-being of seniors?
Yes, absolutely. And I'm glad we get to this right away, because I want to say that for the most part, guardianships can be avoided. They can be rare. No one needs to go through it, except in cases where there's a lot of conflict, maybe between the family, or a bank has a problem or something like that. And the way you avoid that is by planning ahead. You can do it in a number of ways. One is, like I already mentioned, the power of attorney, where you give someone the authority to take over your affairs. In Illinois, we have two types: healthcare and property or financial powers of attorney. And you name people that you want to take care of things. Once you do that, there's no need for a guardianship in most cases. There are always exceptions, but in most cases, you won't ever need to go through this process, and you get the people you want, because banks will honor it, hospitals will honor it, doctors will honor it. Unless there's some sort of weird question, of fraud, they will take those and honor those, and so you don't need to go through it. And on the financial side, which again, power of attorney for property does deal with finances. The other thing you can do is you can look at a trust if you want for your financial matters, and that will also be honored as well. So that you've picked someone who you trust to take care of your finances very completely there.
Okay, so that leads us to the next question. What is the difference between a guardian of the person and a guardian of the estate? And when are they both necessary?
Right. So, guardian of the person is when the judge says, basically, I need somebody to take care of the daily life, the activities of daily living of the person, but not the finances. The property aspect of it is separate. And then the flip side is equally true. So then they can say, well, actually, their daily life is okay. They can manage, but they need someone to protect the finances, to help manage the finances. I'd say that's the more common if it's not going to be complete or plenary guardianship. It's more common that you'll see someone be allowed to continue to take care of their daily life and not be bothered, but they need help with finances. So again, it'll just be decided on an absolute case-by-case basis based on what's needed for you. The one that I would say is uncommon is where someone will have a guardian appointed for them just because of physical limitations. If you think about that, as long as your mental faculties are there, you can make decisions for yourself. The fact that you're physically limited isn't really what we're talking about here.
Right. Okay. And I'm sure this happens a lot. There can be conflicts and disputes. How are those resolved within the legal system?
Sure. So those can happen from the very beginning of a guardianship and throughout. Oftentimes, the conflicts can be between family members. So I don't think I'm going to surprise anybody on the call to say that family members can often disagree about what's best for mom or dad or grandpa or grandma, as the case may be, or anyone else. And so they'll have strong opinions about that. And they may not like what the guardianship is doing, or they may not like who the guardian is, and they may want to challenge that. All of those things can be addressed during the guardianship through that court process. So even though, like I said, a guardianship is established perhaps early on, it can be modified. And those modifications come about sometimes because of conflicts like these, where they go back in front of the judge and they say, we have new facts and we want to change the deal, so to speak. So it's handled through that process.
Okay. What is the process for terminating a guardianship arrangement for an elderly individual?
Sure. So that's not that common. I'll be honest, because usually the things that lead to guardianship don't get better. Dementia being the number one indicator of that. But should we have a good circumstance where that guardianship can go away, all that needs to be done is the senior who has the guardianship on them can go to court and again ask that court by way of a motion to terminate it. A family member as well, actually anybody can, even the guardian can do it, can say everything's better. The reasons that we went into the guardianship were temporary, which would be great, and we can just end the case, and then the judge, if he or she agrees, will do that.
Okay. What safeguards are in place to prevent abuse or exploitation by a legal guardian?
There's a lot. There are required filings annually with the court. So there's a requirement that they keep track of absolutely everything they're doing. So any financial exploitation would be difficult to engage in. It's more common that the exploitation actually occurs before the guardianship. And that's part of the reason why the guardianship is created, because either a family member or a caregiver, I'm sorry to say sometimes, will do that exploitation. And so you get the guardianship to stop that. But if that were to happen, if a guardian were to abuse their position, the court has the ability to watch that. All of it's transparent with any of the interested parties, which basically means family members, so that everyone can review what's happening. And if they see something that's wrong, they have every right to go in and challenge that guardian in the court. Again, court's job is not to protect the guardian, it's to protect the person, the senior.
Right. So I think you said, and correct me if I'm wrong, you go before the judge annually?
There's an annual report that's filed.
Okay.
There's not necessarily an annual appearance, although maybe for the attorneys who have helped process the guardianship, but typically not for the senior themselves. They don't have to go to court for that unless something has happened significant.
Okay, so they just provide documentation.
Exactly.
of what
Exactly.
they've done. Okay.
And everybody, all the family members or the interested parties have a right to see that to make sure
Okay.
it's being done correctly.
Right. That's helpful. So can an elderly individual choose their own guardian in advance? And if so, how is that legally documented?
So they can't. You can't choose a guardian legally, but you can express your preference for that. Again, in the power of attorney, you can say, if a guardianship is needed for me in the future, I really would prefer this person be that person. And you can name a couple. You can say 1, 2, and 3, if you will. The judge doesn't have to agree. They'll take that into account. It'll be a factor, and mostly it'll be an important factor. But if there's a good reason not to appoint that person, the judge has that right. But so you can't just blanket say I want this person, but you can make that request, and it's a strong indicator.
Right. Okay. How does guardianship intersect with other legal documents like powers of attorney and living wills in elder law?
Yep. So, like I said, the hope is that if you have a well-drafted power of attorney that nobody has any real questions about, the intersection will be they won't intersect because you won't need the guardianship. Instead, you'll have the exact person you would hope taking care of you doing that, and they won't need to. They do intersect, though, if there's a problem. And I'll give you an example. Let's say the power of attorney was drafted a number of years ago, which can be done. There's no time limit on that. And things, you come under hard times, and a bank has a lot of your money. And the bank is concerned about you and doesn't necessarily trust that the person you named many years ago is still who you would have wanted. Sometimes banks get protective of their clients. So a bank could just say, I'm not going to take that power of attorney. I'm not going to accept it. And right now, in many states, they have the right to not accept it. That would then force you in those circumstances to go into court. So that's one of those intersections where the power of attorney is there, but possibly you'd have to go into court anyway. Now, the living will, again, this is where states will vary. In Illinois, the living will doesn't concern itself with guardianship or appointing people. It's just an expression of what you would want to have happen in the event you need life-sustaining treatment. So it's a very limited document. I'll always tell you that I'd much prefer you to not have a living will, although you can have one, have that power of attorney, because power of attorney does that plus way more.
Okay, that's great information. Are there specific legal requirements or regulations related to guardianship in Illinois that seniors and families should be aware of?
I would say no, in a way. I mean, there are a lot of regulations. There's a whole legal process around it, but it is not the sort of thing that you as an individual layperson need to be aware of. What you need to be aware of is that you have good planning in advance, like I said, so that you don't ever need to worry about a guardianship, or hopefully you won't need to. So things like the power of attorney, your last will and testament, trusts, if you decide to go down those paths, all those things are the things you need to be aware of and thinking about. The guardianship is a backstop if all those things fail. And that's why it's there. It's there as that last step, because nobody really wants to go to court. Nobody wants to have a guardian appointed, but it's there if we need to. And I often have said, Sonia, in our previous talks, it's going to be okay, right? Whether you do planning in advance, which would be great, but let's say you don't, it's going to be okay, because we have systems like this in place that are designed as a backstop, so that if you have done nothing and this comes to pass, we've got you covered. The system's got you covered.
Okay. We have a question from YouTube. Someone is asking, what do I need to do to get a power of attorney for my elderly brother with dementia?
Oh, so that's hard. That's a really good question, because you've keyed on the most important part of getting a power of attorney, which is they have to be of sound mind and body, or not body, but sound mind to execute the power of attorney. So if the person is suffering from dementia, it's not impossible, but it is hard to get that to be valid, because if they are not aware of their own circumstances. They're not oriented to time and place. They don't necessarily know who their family is or isn't at that point. If they can't answer those questions, you probably can't get a guardianship or a power of attorney. That means you are left with the option of a guardianship to be able to help them. But like I said, it's not impossible. Let's say that person, I'm just going to say mom or dad, you said brother, actually, the question was
Right.
brother. So let's say your brother has good days and bad days, right? If that's true and they have a good day and you've already prepped with an attorney, the power of attorney, the way that your brother would have wanted it, if they have a good day, you could execute it then. It doesn't mean that if they suffer from dementia that they can't ever execute it. It's they can't whenever they're in that circumstance where they're just not aware of themselves. But if they have a good day, you've got a shot at it. So maybe. But then also the problem is that other people may not believe it was during a good day. And so banks or other institutions or other family members may not agree, and that'll thrust you back into the guardianship process. But you have a shot, but it's a tough one. I feel for you.
What if you got that brother's physician involved to say, to get documentation that he has dementia, and maybe you're the person that brings him to the doctor, and
it could help. It could help. Again, I mean, maybe even if you have some of the witnesses to the power of attorney, maybe they would, let's say he's in a nursing home. I don't know if he is, but if he is, the caregivers there might be able to attest, yeah, this was a good day. He was fully aware that day. Again, at the end of the day, if someone says, no, I'm not going to accept it, you may be forced to the guardianship. But all of those things can add to the shot of maybe it being honored.
Right. And so it's very specific to every single person.
Absolutely right.
Yes. Okay. And as we've talked before in our conversations, the most important things are everything is going to be okay, as you tell us every time, but also planning ahead.
That's right. Planning ahead here, and everything is going to be okay. For those who this is the first time listening to one of our conversations, that is something I try to reassure people with, because oftentimes when clients come to me, they're very worried that things aren't going to be okay because they didn't do the planning that they should have done. Will that affect things? Sure, it will affect things, but will it mean that you can't get the outcome you want for your life, either for your own life or your wife or your husband or your family members? No. There are so many different steps in the process that no matter where you are in that process, there is a good way to get you to where you want or where you need to be. So absolutely, I think a lot of times attorneys will be scary. I'll be perfectly honest. We'll scare people and say what a problem this is. I take the exact opposite approach. We can solve your problems. It will be okay.
Right. All right. Well, we're out of questions. So today's questions hopefully will help you explore some various aspects of guardianship in the context of elder law, and hopefully make you start thinking about planning ahead. Keep in mind that the specifics of guardianship laws and procedures vary by jurisdiction, so consulting with your own elder law attorney in your area is advisable for personalized guidance, because as we said, every case is different. Every individual's situation is different. I want to extend our heartfelt gratitude to our esteemed guest, Steve Andersson, for sharing his expertise and insights with us today. It's always great to have these conversations with you, Steve.
It is. Thank you.
Yeah. For those looking for more resources on caregiving, you can find valuable information and support at the Illinois Department of Aging's website at ilaging.illinois.gov and at AARP's caregiving site, www.aarp.org/caregiving. Please take advantage of these resources to help you navigate your caregiving journey. Once again, I thank you all for joining us today. We look forward to continuing our mission of supporting seniors, caregivers, and the entire aging community in Illinois. Have a wonderful day, and this concludes today's virtual event.